There's Mr. Wilson. Okay. Ms. Perry, you're up.
Good morning, Your Honors. May it please the court. My name is Allison Perry, and I represent the appellant, the former wife, Megan Sunderworth. I'd like to reserve 5 minutes for rebuttal, please.
Sure.
Okay, thank you, Your Honor. The former wife appeals a supplemental final judgment that revised a marital settlement agreement, parenting plan that was incorporated into their final judgment of dissolution of marriage. She also appeals this order because it modified the child support because it imputed over $3,000 of in-kind income to her for child support purposes. And she also appeals the court's modification of the children's child support exemptions that she used to have both of the child support exemptions, and the court changed it to giving one to the husband and one to her. Excuse me. The wife contends that the court utilized an incorrect law in reaching its decision to modify the children's time sharing. So this court reviews this application of law de novo. The court found that the wife waived her right to require the husband to show a substantial change in circumstances to carry that burden to modify the children's time sharing. And this because she agreed to a temporary modification of the children's time sharing schedule. And this, of course, is not the law in Florida.
Let me ask you a question, Ms. Perry. I'm sorry, I didn't mean to interrupt you, Judge.
Go ahead.
What would prevent the former husband in this case tomorrow file a petition for permission to relocate and attach, as the statute requires, the proposed alternate parenting plan?
A petition to relocate, you mean to relocate?
Petition to relocate.
Where he's living now?
No, from Illinois to where he's living now. Get permission to do what he's already done. Because that happens, right? That happens.
Yes, he absolutely has the right to do that.
And what would, as the statute contemplates, and Mr. Wilson pointed out in his briefs, to do that, you have to show what the alternate parenting plan is going to be based on the move. Isn't that what's happened? Isn't that what happened in this case?
The alternate parenting plan when there's a move?
There was a move. He petitioned for a new parenting plan. He also petitioned for a declaratory judgment about whether he had to seek this permission, but that got, the party said, oh, you don't have to do that. But what if he did it anyway and submitted a new parenting plan along with that petition?
Well,
I mean, what I'm trying to get at, Ms. Perry, is I don't see how your client was harmed.
It's not
on the modification of the parenting plan.
It's not my client that I'm concerned. I mean, I am concerned with my client, but res judicata attaches to the final judgment because the case law holds that stability is what's best for the children.
And the statute, and also the statute contemplates that a parent can then relocate and ask for permission, and as part of that, come up with a new parenting plan.
And the statute also requires under 61.133 that a determination of parental responsibility, a parenting plan, or a time-sharing schedule may not be modified without a showing of substantial material.
Of course, I get that. But isn't there a tacit statutory acknowledgement that that move in itself was a change of circumstance, and that as a matter of law, it can support a change of parenting plan?
No, the law actually in Florida is that the relocation of a parent cannot qualify as on its own as a matter of law as a substantial change in circumstance. Well,
then why does the statute provide that when you petition for a modification, you have to propose a new parenting plan? For purposes, if you have a petition for permission to relocate, you have to propose a new parenting plan.
Because that's if you're relocating, but that's not, let me think for a second.
Yeah.
Well, that's a good question, but you still have to prove a substantial change in circumstances, and you have to show that it was unanticipated. And in this case, it was anticipated that he was going to be moving
It wasn't,
to be
that,
near
it
the
wasn't,
children.
that wasn't anticipated in the original proceeding by the judge, correct? He had it in his mind that he might move, right?
It was the testimony was that he planned on moving back to be near the children. That is in the final
In
judgment.
this proceeding or in the proceeding that led up to the final judgment dissolution?
In this proceeding, he testified, and it's in the actual supplemental final judgment, that he planned on, at the time of the final judgment, when they entered into the marital settlement agreement, he planned on moving back to be near the children. So
And it
wasn't
could be perhaps that he planned, that at the time he planned to file a petition for permission to relocate and propose a new parenting plan at that time. If that had been in his head, you're still saying he still could not have done that.
You still have to show a substantial change in circumstances that was unanticipated. If he was anticipating relocating, he shouldn't have entered into that agreement. There should have been a different agreement. There should have been a backup agreement, especially if he knew he was going to be moving.
But Ms. Perry, in this instance here, the judge found that there was an agreement and therefore there was a waiver by the former wife. And we don't have the benefit of a transcript to know what the judge actually heard, what the testimony was of the wife. And so doesn't that hinder our ability to do anything here with the relief that you're requesting, regardless of whether this was unanticipated or an anticipated change?
No, Your Honor, because the agreement that he's speaking of is the agreement to temporarily modify it. And that order that came out, because there was an actual written agreement for them to modify on a temporary basis. They agreed because they were about to go to trial and she had to get a new attorney. And so they agreed to temporarily modify the custodial arrangement, and they entered into a temporary agreement. So that was a temporary agreement. There would have been no need for the final hearing if she had agreed to waive the substantial change requirement. Plus, you cannot waive.
That's not true. You would still have the litigation over what the parenting arrangement would be. You would still have the litigation over the child support aspect of it. I mean,
That's true.
The judge said, hey, she waived this aspect.
But you can't waive substantial change of circumstances. There's cases out of this district that state that. And Jonata v. Hess out of the first district, I believe. Yes. And that's in my brief. It's at 959 Southern 2nd 373. It holds that when a party seeks modification, you have to show a substantial change of circumstances. And if you do a temporary modification of an agreement, it cannot constitute a basis for a modification of custody, because it would discourage parents from temporarily modifying the time sharing arrangements that's in the best interest of their children. So it says you cannot hold it against, you still have to prove a substantial change in circumstances that was unanticipated. You have to follow 61.13 subsection 3. So there was no substantial change in circumstances. There's a recent case out of this district that was that I sent in as supplemental authority called Edelson v. Carmer. And this court just reversed a case where there was an agreement in there was agreement that one of the children, you wouldn't have to prove a substantial change in circumstances. And the court went and modified and said, I'm not going to make him prove a substantial change in circumstances to any of the 3 children, and modified the custody. And the court said, you can't do that. You can do it to the one child because the parties waived the requirement that there be a substantial change in circumstances, but a determination of parental responsibility.
That sounds like you just said they can waive the issue of substantial.
No, not, I'm sorry. And that's incorrect. If the final judgment if a determination of parental responsibility, a parenting plan or time sharing schedule may not be modified without a showing of substantial material or change of circumstances unless there is an agreement, unless there is an agreement that, like in this case, the child was at a young age, and they said, when this child gets to be a certain age, we will agree that by motion, we will establish the child's parenting schedule. And so that's what they did. But when they went in to change establish the youngest child's time sharing schedule, the judge altered the older two children's schedule without having to prove a substantial change in circumstances. And the court said, you can't do that. So this case said, you have to have a substantial change in unanticipated changes in circumstances.
Can I
And there's
ask
just-
about oh, go ahead. Sorry, I didn't want to cut you short on this.
I'm done.
Can I ask you about the expenses paid, living expenses paid by the fiance? I'm not sure I differ with you. I didn't look into it very closely about whether reimbursed expenses or in-kind payments to the extent they reduce living expenses under the definition of gross income could sweep within its ambit the kindness of strangers or fiancés. It does seem like it's a plausible argument that was intended to mean by your employer. But isn't there another way of looking at the analysis of the trial court? In other words, it's not that the trial court was necessarily saying this is gross income, but rather that they weren't expenses at all. In other words, in the net income, those do not need to be, or as another way of getting to the point from A to Z is, well, she didn't even incur those expenses, so they don't. Now, does that make sense?
Well,
Go ahead. I'm sorry.
If she didn't incur,
Does that make sense?
if she didn't incur those expenses, then he could say they shouldn't be on her. They shouldn't be on there on her.
Yeah, in
financial
his
affidavit.
judgment, in Judge Ransberger's judgment, he said that affidavit, which was August 2019, he found to be the accurate one. Correct? He didn't say the
Yes.
expenses were not incurred.
Yes, but
I guess
let me tell you,
is that tipsy coachman? Does the coach get to the right place if you're saying, well, yeah, it's not actually income, because you can't attribute that's not like her employer, paying for her leasing her car, but rather it doesn't need to come out. In other words, it's either gross income, which doesn't fit into that square hole, but it should somehow come off in some way because she really didn't incur those expenses.
Well, I think Judge Atkinson, the issue, and I'm sorry, I don't mean to be taking up the argument here, but the inquiry under 6130 is what is your income, not necessarily what your expenses are.
No, of course.
Some expenses are deductible from gross income, but not all of your expenses. So that wouldn't solve the problem by looking at it that way.
Well,
It's not. This is not money coming in.
I'm raising a tipsy coachman argument. In other words, does he get the same spot?
no.
And the answer is no. For purposes of the calculation of income, that answer to that question is no. I mean, I can just tell you that. I think Mr. Wilson would agree too, that the way the child support works is what income do you have coming in from these sources? And it can be an in-kind. So like the employer furnishes you a car and it reduces your living expenses because then you don't have to have your own car. So that would be income. But what you're paying for groceries doesn't come off of your income for this purposes, and it doesn't constitute income.
Absolutely.
So
Like I said, I conceded from the outset the problem, and I'm just asked. I
don't think that approach works. Bottom line.
Ms. Perry,
So the problem
Perry, let
being that's not income. I conceded that at the
Right.
outset.
Ms. Perry, let me get to one of your other arguments, which is the IRS dependency deduction. How with your argument that should not have been taken away from her, she wasn't actually declaring the children,
No,
correct? It was the fiance. So
Correct.
how can you make that argument?
well, she was benefiting from it because she was living in an intact household with the fiance and the children.
That's a pretty attenuated, issue. She's not, clearly she has no income that she's reporting, right?
Correct. Well,
Okay.
she has rental income, which was reported on her most recent financial
But
application.
but she is not claiming the child deduction.
Correct.
So I don't see how she was harmed. And it seems to me that it makes sense for the judge to try to maximize the benefit of that for the parties.
Can I get back to I wanted to talk about Hinton v. Smith, because Hinton v. Smith has to do with the in-kind contributions. And that's a case out of this district, out of your district court, which holds that, we believe the legislature intended to reimburse expenses and in-kind payments to cover items such as food, housing, and vehicles furnished by the employer who's paying wages. The effect of a former spouse's remarriage to a new spouse who can contribute to expenses may increase the former spouse's disposable income after he or she pays child support obligation, but it plays no role in calculating child support.
And let me point out to you, Ms. Perry, that we have also consumed 15 minutes of your time. So you do what you wish with the 5.
I'll reserve. Thank you.
Mr. Wilson? Mr. Wilson? Oh, there you are. Sorry.
Thank you. Little button issue. Good
Well, I didn't know whether you just didn't hear me. I'm looking at my microphone settings. So
Good morning, Your Honors. Attorney Matt Wilson on behalf of the appellee, Jonathan Sunderworth, and may it please the court. As the court noted in the appellant's presentation, one of the issues that we had, and I had the benefit of being the trial counsel as well, was a determination as to whether or not the relocation statute would apply. Under my technical definition and reading of the statute, it certainly would have. And with that, under 6113.001, there is an assumption that a trial court will modify the parenting plan in granting the relocation. At the pretrial conference, the parties stipulated and agreed that the relocation statute would not have to be pled and sought. And under that premise, we moved forward on the supplemental petition, which in the trial court setting, it was originally set for trial, and the parties reached an agreement as to what was called an interim order with transition time sharing agreement. At some point in time, the verbiage of temporary has taken a life of its own from the premise that even the trial court itself had occasion mentioned the words temporary time sharing. But ultimately, in that agreement, the parties stipulated and agreed that the entirety of the non-school time sharing would be modified to be split equally between the parties, not on a temporary basis.
Mr. Wilson, this was a final hearing, right? On the petitions that were filed by both parties.
Yes, it was, Your Honor.
Correct. Okay. But looking at the final judgment, supplemental final judgment here, it says the court's going to consider this to be a temporary parenting plan. Where did that come from in any of the arguments by the parties, or where do we see that? Because if this is supposed to be a final hearing, this should be a permanent parenting plan, and with the parties still having the ability later down the road to petition if there's a substantial change in circumstance to a new proposed modified parenting plan. So where does that temporary language come from? Or why is it there? Do you know?
I do, Your Honor. Yes. The trial court heard from the guardian ad litem, which was appointed in this case. And the guardian ad litem said for the time being, the 4 out of 14 schedule that the trial court ultimately entered was in the best interest of the children. But if the opportunity for the transition of the father from Illinois to Florida took what she anticipated being the necessary steps that she could forecast, I believe, I don't want to misquote the guardian ad litem in this matter, but that ultimately the 50-50 time sharing schedule may be appropriate. The trial
And that doesn't sound like that. If that's the case, then is that a final order?
And the trial court debated that at the motion for rehearing as well, as to whether or not this met the criteria for definiteness. And as the appellant has noted in the briefs, and we don't object to the citations there, certainly, is that the trial court's requirement is to generally get definitiveness for finality purposes. There is no dispute that this trial court said at some point in time down the road, we may have to address the schedule, and posed for the parties to acknowledge to the court whether or not they were willing to stipulate the future modification.
Which,
Substantial change in circumstances.
Now, even with that language that the court has in there, if later down the road and with the opening left open by the guardian ad litem in the court, the parties would still have to, or let's say in this instance, the former husband would still have to make the proper showing of change in circumstance, correct?
It is an interesting question, Your Honor.
Well, but it's interesting, but the fact of the matter is that the burden would then be on him to make that showing, because there's nothing in the order that says that if he does this, or that the party stipulated that would be a change in circumstance, substantial change in circumstance.
And I say interesting because the standard on a temporary parenting plan is the legal requirement of good cause shown to adjust the temporary time sharing
And
schedule.
so what is your position? Is this a temporary or is this a permanent parenting plan?
The black and white letter of the trial court's order is that this is a temporary parenting plan.
So this was
Yeah,
a
and
client.
let me go ahead, Judge Smith. I'm sorry.
No, go ahead, Judge Northcutt. I'll follow
Well,
up after.
the concern I have is the law, and Ms. Perry kind of touched on this, has touched on this too. The law is, there are areas in family law that don't really match up with the strict language of statutes. For instance, if we treated this as a final parenting plan determination, such that the dad would have to petition for a modification upon the happening of the things foreseen by the guardian ad litem, there would be an argument, Ms. Perry would probably make it, that, well, this was not unanticipated. So therefore you can't change. Even though everyone at the table knows at this point that when these things happen, the guardian thinks it's a good idea to go to the 50-50 and the judge thinks it's a good idea to go to 50-50, but the judge also can't order a modification in the future. So there's kind of a catch-22 there, which is, I think, why the judge said, okay, this is temporary. Because, everybody's, because there are anticipated circumstances that are going to arise. And under a strict reading of 6113, you couldn't get the modification because you anticipated them at this time.
And that, Your Honor, was certainly one of the concerns we raised in the brief, and the fact that when and if these circumstances do fall in line, then there would be a challenge as to they could not have been unanticipated because the guardian ad litem set forth the blueprint. And I think that segues, I do believe that segues into some of those temporal challenges that a trial court is dealing with and trying to ensure that we are structuring these orders. And I also would say that the original supplemental final judgment preceding the the motion for rehearing was entered in July of 2020. And quite frankly, I believe the trial court's anticipation would be that if either party was going to be addressing either the expansion or the maintenance or even the reduction of the time sharing schedule, a year later was probably the timeline, but for the fact that we're in this appellate posture, which again, the trial court itself has said the words temporary, reserving jurisdiction to readdress that. We just have not gotten to that stage in the process.
Can always switch to the child support issue? I'm sure we can, if I say so. And the mom's income here. I have not ever seen an order like this that says, oh, well, for number one, on what is it, Hinman, was that our case? It says that's distinguishable because that case involved income of a payor and this involves a payee. And I can't for the life of me find anything in the law that says calculation of parties' incomes for purposes of child support depends on who it is, payor or payee, number one. And number two, I've never seen an order that says, oh, your expenses are your income. I mean, there was no testimony to that, right? I mean, the judge in the order said, the fiance didn't come in and testify to what he was paying.
That's correct, Your Honor. And nor have I seen any case law that distinguishes between the payor and payee.
I don't think there is any because the statute doesn't say there is a difference, correct? So how does that distinguish our case law on this point?
Well, the appellant cited to Callwood extensively, and in that respect, that was a situation where a party had just returned from prison and was receiving both in-kind contributions from family members as well as what the court determined to be gifts for purposes of calculating what would ultimately be the gross income netted under the requirements of the statutory analysis for a net income. And from our perspective, the final financial affidavits that were entered into this trial as exhibits were worrisome a number of reasons given the inconsistencies. And I think
but the judge found and said in the judgment, the August 30, 2019 financial affidavit is the one I find to be credible. That's the number. And number one, I don't see how someone paying your expenses, your items on your cost of living has reduced your expenses. So like if an employer, the common example is an employer furnishes you a car. Because the employer has furnished you a car, you don't have to have a car. That has reduced your living expenses. But what that financial affidavit showed was what her living expenses were. The fact that the fiance was paying them didn't reduce those expenses.
And nor did the trial court make that determination.
And yet that's how the trial judge had to characterize it that way, because he said these are in-kind contributions and therefore that's your income for purposes of child support. And in-kind contributions only get calculated to the extent, I think that's the language that the statute says, to the extent that they reduce living expenses.
That is correct. And certainly from the standpoint that the trial court saw the tapestry of the various financial affidavits were one, she was listing some income. One, in this instance, the one the trial court relied on, she was at zero income. And I believe the trial court making a determination that there needed to be some income attributable to her under its rationalization of the interpretation of 6130 as to the payee, determined that this was the best approach for.
Okay, so you've identified several potential points of error. It's from my perspective. There was no evidence to support, the payments of $3,000 odd. And two, there's no difference between a payor and payee for these purposes.
That's correct. And certainly it would have been a guidance for appellate review if the trial court had further articulated how it reached that conclusion in terms of trying to ensure that ultimately the child support was reduced by a de minimis amount from, I believe it was $1,500 at the time of the entry of the final judgment to $1,334, if memory.
I get it, because it all, the way child support works, there's not those big swings, but there you have it, Yes. I have some real concern about this issue.
And briefly touching on the IRS issue, as noted, the final judgment itself reserved on the necessity of reassessing the tax dependency exemption when and if the trial court recalculated the child support. In the supplemental petition to modify, we used a very generic averment of child support and its components. Not with the intention of having to address the tax dependency exemption. It wasn't until we were in the midst of the trial itself that we learned that the tax dependency exemption had been provided to somebody, a non-party. The trial court originally, in its final judgment, determined that it wasn't pled for and therefore could not be relief granted. And in the motion for rehearing, agreed with the appellee herein that it was properly pled and reserved by the trial court in its entry of the final judgment, and believed that no due process violations occurred to the appellant here. She was on notice, both in terms of the reservation as well as the pleading. And ultimately, the fact herself disclosed at the final hearing on the matter that she was giving the tax dependency exemption. Again, we believe there's no due process violations, and certainly from the standpoint and the sound discretion of the court to reallocate that part and parcel to its recalculation of the child support.
In your view, if the mom marries the fiance, or breaks up with the fiance, Would that, either of those be a basis for modification of this provision to restore the tax, child tax exemption back to her?
I think if she were to then seek that, yes, I do believe that would be a basis. I think the intent of the reservation in the trial court's order was to, and as noted in the briefs, is to maximize the amount of income each party has available for purposes of child support. So I believe
Right.
under either of those circumstances, she would have that right to seek a modification of the tax dependency exemption.
Going back to the fiance issue, you haven't, and I don't blame you, taken up my creative tipsy coach. Could you, your argument in the brief was pithy by comparison. Could you just walk me through what is the argument considering Hinton? I mean, my memory of Hinton has to do with whether that can be considered income, but that is what the court did, right? And what exactly is your argument for that not being reversible error?
I think ultimately from the perspective of the fact that the trial court heard the testimony of all of these expenses and that she was not the one paying them and they were sustaining them, an interpretation of either in-kind contributions or gift is the best approach the trial court could come up with putting a dollar amount higher than zero. And in that respect, again, that's why whether it be a pithy argument in the briefing or just in the discussions here today, I am not in a position to reconcile how the trial court came up with that solution, but ultimately from the standpoint to ensure that the children were being adequately taken care of with the support that the court ultimately did award, including an application retroactively of which the former husband and the appellee herein was required to pay. So the short answer is, again, not using the tipsy coachman doctrine and not being in a position to fully articulate where the trial court was going with that calculation. That's the best I could see as to trying to get to a solution that pointed an income, use 6130. In this instance, it would certainly be liberally interpreted and create a solution that was best for this family.
Or not, depending on your perspective.
Certainly, Your Honor. If there are no further questions, I will cede my remaining time.
Thank you, Mr. Wilson. Okay, Ms. Perry, you're up. And you are muted. You're still muted, Ms. Perry.
Sorry.
That's happening all the time.
The only difference between Hinton v. Smith in this case is Mrs. Hinton was married, and the trial judge in our case was actually thought that Mrs. Hinton was the payor, which I understand why he got it from the language. But if you read the whole case of Hinton v. Smith, she was actually receiving child support because she was seeking to get an income deduction order. So the judge actually got that part wrong. So Hinton v. Smith.
The statute does not differentiate when calculating, determining what party's income. It doesn't matter whether they're pay or correct.
Yeah, and in fact, both parents are payors of child support. It's just that sometimes someone gets. I mean,
right.
So
both parties are deemed to be contributors to the support of the children, and it nets out who owes more versus who owes less. Correct.
Correct. And in Hinton v. Smith, the only difference is Mrs. Hinton got remarried, and that's even more stable relationship than our case where she's just engaged to the gentleman. So certainly they shouldn't. It's like they're trying to do a supportive relationship on an alimony case. I mean, that's what the judge pretty much did. And I know you know what I'm talking about in 61.14 is in a supportive relationship, you can impute income for someone who's in a supportive relationship. That's sort of what the court did.
Well, and again, there was no evidence that was referenced in the judgment that he reduced her living expenses. Correct.
Correct. Okay. The child support issue, the tax exemption issue, that was not pled for. And the court ruled that it wasn't pled for, and then changed its ruling on rehearing and decided to rule in the husband's favor.
Well, but in fairness, as Mr. Wilson pointed out, didn't the judge determine that exemption issue was included in the general prayer for relief on the child support matters, that was encompassed in that.
That's what the court decided, but I believe a more that needed to be pled for is our argument is it needed to be pled for. Another factor of the imputing this income to the former wife is that it was harmful because she is disabled and she's unable to work, and that was undisputed. And also she was paying lots of her expenses with the $1,500 of child support she got each month. So they're counting this $1,500 of child support as income, which you're not supposed to do. So I think I've beat that to death. Again, you have to show, it's black letter law that you have to show a substantial change in circumstances that was unanticipated to get a modification of a final judgment's or time sharing schedule. And that was not done here. That's all there is to it. It doesn't matter if everyone thinks it's in the best interest of the children for this schedule. If that's the Idelson v. Carmen case from June 18th, I asked the court to read that opinion because it goes on and it says, you know, it's not our place to say if it's in the children's best interest. Our place is to say you have to prove a substantial change in circumstances. It was unanticipated, and that was not done here. So, Your Honor, I ask that you reverse the time sharing schedule. It can't be temporary because this matter was ripe for adjudication. You can't put these things on hold indefinitely.
I get that, but there's all sorts of law going back, as long as I've been doing this. It says judges can reserve on issues and decide them later.
But
correct? And so the judge could not the judge have said, you know what? We have this current situation and we have strong reason to suspect it's going to change. And so I'm going to reserve to make a final decision once we see whether those circumstances play out. And they can do that with child support. They can do that with child custody. They can do that with property. Can they not?
My understanding of the law, and it's briefed, is when you are at a final adjudication at a final hearing and everything is ripe for adjudication, that it should be determined by the court.
What the judge said is this isn't right for final adjudication based on the evidence. You're there for a final hearing, and on this issue, he says the guardian ad litem report shows that this is not right for a final adjudication.
But you have to, at a final hearing, there needs to be a final result. That's what the law is in Florida. You can't just leave it open-ended.
Ms. Perry, and in this case, the trial judge discharged the guardian ad litem. Wasn't something that he left that open for a later day. Is that right?
I believe that's correct, Your Honor. I'd have to look that up to make sure.
So and I'm certainly putting you on a spot on a hypothetical that may or may not happen. But so if the dad comes back and says, okay, so the judge enters a final order with the what is currently called a temporary arrangement. He issues that as a final judgment, and the dad comes back and says, okay, I'm ready to go 50-50. And the guardian ad litem, as the judge acknowledged, said that's really where we ought to get, and these things have happened. Your position would be that's not a change of circumstances, and he wouldn't be able to do that because it was anticipated.
Yes. It's absolutely.
Even though the guardian ad litem could say, this is ultimately the best interest of the children are going to be served by, being 50-50. And now we're at that point. And because it was said in the guardian ad litem's report, he wouldn't be able to get that modification.
That's the law in Florida, is a substantial change in circumstance. It's the actual statute. It's not just the case law.
No, I get that.
So that's the law. It's there for a reason. It's there for res judicata. It's there to give stability in the children's lives. It's to probably keep the court system clear so people aren't going to court every other month. And, in this case, there needs to be finality. And there should be a fine. It should, in fact, this court treated it like a final order.
Oh, I get that.
I mean,
Except for
I don't know.
parenting
Is it
plan,
a-
except for the parenting plan.
yeah, I don't know. Is it, because this court decided,
Yeah, if it's a final judgment, which I think it probably is a final judgment, the scope of review is anything that happened before the filing of the notice of appeal. So it's a final judgment. Certainly, we can review non-final orders that were entered, before the notice of appeal. So, we treat it as final judgment. I get that, and for jurisdictional purposes, I think it was or is, but there can be aspects in a final judgment where the court reserves to decide an issue later. I mean, that's just happens.
but there's law that says you should not do that.
Should not or cannot. I mean, the question is as a matter of law, is that error, or is it subject to an abuse of discretion standard?
Well, especially it's probably abuse of discretion standard.
Yeah, probably. And so you would be arguing that we have to conclude that no reasonable judge would have done that in this case.
Well, under the facts of this case, after many, many months of litigation over this issue, it should have come to finality. It's in the best interest of the children that they have a schedule. I mean,
Well, they do have a schedule, do they
Well,
not?
and let's say there's months down the road where the father actually, certain things come to fruition as the guardian ad litem may have anticipated. We don't look at what happened at the final hearing or the report of the guardian ad litem. We look at that time and place when the modification is sought. Is that right? So, I guess my point is that later down the road, I mean, let's say this is a temporary parenting plan and the judge is anticipating these changes. And if the changes do happen, there's still a point in time down the road where the court has to look at it from the modification standpoint, from that point in time, as well as the best interest factors, then not what happened in the past.
Correct.
Correct. So the judge isn't saying, I'm not ordering an automatic change, correct? Because he can't do that, right?
Correct.
He's reserving, because it's theoretically possible that suddenly, what if his job situation changes and he gets transferred out of state?
Well, now we're just talking about lots of hypotheticals.
Yeah, but what we do know is the guardian ad litem said they probably ought to be 50-50, but it's not time to do that yet.
Yes. But we
Okay,
also know
We have used up some of the time that Mr. Wilson ceded. And so we're well beyond your rebuttal, Ms. Perry, so we probably ought to stop. In fact, we definitely should.
okay, thank you, Your Honors. I
Thank you both very much.
Thank you.
Interesting case.